number 5, People v. Charles Howard.
Good afternoon. I'm Howard Comet, appearing for the defendant, Charles Howard. May I please reserve 3 minutes for rebuttal?
Yes.
Thank you. The defendant has raised 2 issues on this appeal. Although the issues are separate, they both concern whether the evidence at trial was sufficient to prove beyond a reasonable doubt that he was guilty of robbery in the first degree, as opposed to a far less serious charge of larceny. The issues also both involve somewhat unique circumstances. The first issue is based on what we've referred to as the sole witness rule. That's the rule that when all of the evidence of the defendant's guilt...
So, counsel, does it make a difference for purpose of the analysis that the victim didn't get on the stand and admit that they had made that prior statement, but rather said, I don't know, I don't remember? Does that matter for purposes of our analysis?
I don't believe so, Your Honor. It certainly...
Why not?
Well, it certainly would have mattered if he said, I didn't make that
No,
statement.
correct, because then it's clear you've got 2 different
Well-
statements. One appears potentially inculpatory, one appears potentially exculpatory. I get your argument there. But isn't it for the jury to resolve whether or not they believe his statement that, as I have described it at trial, that is what occurred?
Well, except that the prosecution also put on a witness, their witness, who said he made a contrary statement right after the crime.
But counsel, that raises a bigger issue for me because I don't see this as a sole witness case. There's 2 witnesses here. There's the prosecution's witness who says this victim said this, and the victim who says, no, I didn't say this. But that statement that comes in from the prosecutor's witness, the detective, isn't admitted for the truth, which makes this such a different case than Fratello to me.
Well, the victim here did not say that he didn't say it.
No,
Yeah,
but
okay.
there's no contradictory statement in evidence for the truth. If a victim gets on the stand, the classic case, and says one thing and then later says a contradictory thing, you have a single witness problem. In Fratello, you had an excited utterance case, victim recants later. They bring in the excited utterance for the truth of those statements. In fact, I think the conviction rests on the statements. In this case, the statements only come in to impeach. So there's no dueling statements and evidence from one witness. One witness has one story, and one witness is used to attack the credibility of that other witness, right?
Yes, Your Honor. Let me try to answer that in 2 ways. One is there authority already that the sole witness rule applies in this situation?
I disagree with that, but go ahead. The Judge Graffio opinion, right, later. But that seems to say the sole witness doesn't really apply here. That's Della Mota?
Della Mota. Your Honor, that says, and this is at page 115, I believe, of the opinion, it says, with the exception of the limited scenario envisioned by Ledwan and his offspring, we are not empowered to upset a conviction because the differences between the pretrial and trial statements of a witness. And of course, the pretrial statement of the witness in Della Mota was admitted only for impeachment. If you turn that sentence around, say the same thing, but in an affirmative way, what it says is, in the scenario envisioned by Ledwan, we are empowered to upset a conviction because the differences between the pretrial and trial statements of a witness.
But again, this is my problem. Let's go with this argument about or questioning about the impeachment. If the witness is not admitting
Right.
or saying that I didn't say it, so they're not being impeached in that the truest sense of you said that then and you've said this now. What are we to believe? He's saying, well, I don't know, I don't remember.
Well, but then you have an undisputed testimony from the prosecution witness that he did say that. You have no reason to doubt that testimony. It was never disputed.
But I'm saying, yes, I'm
Isn't
sorry.
that a jury?
That was my point.
determining
Isn't that for the jury to determine whether or not there was a prior statement, what that prior statement was, and whether or not it's inconsistent, and then what to do with that?
Well, there was, let me answer, there was no issue for the jury here, really, as to whether there was a prior statement, because you have undisputed testimony. You also had 4 people
That
at this.
doesn't mean they have to believe it.
But counsel, it's the use of the statement. I think what you're hearing from various people is that prior inconsistent statements get admitted all the time, and they go to the credibility of the testimony that was given in court.
Yes, Your Honor, but the whole point of the sole witness rule is credibility. The whole point of the rule is that when all the evidence of guilt comes from a single witness who is given conflicting, exculpatory, and inculpating statements, then the jury can't properly assess his credibility.
Yes, but that's my point, whether or not there was a prior statement that is as the officer describes it. The witness is not admitting, and there's not someone else who says, yes, that's exactly what they said.
On what basis would the jury not find that he said it when nobody disputed it at
Because the
trial?
witness is saying this is how it happened at trial.
Yes, but then that just creates the conflict that
It
gives...
creates a conflict of credibility. They might say, you know what, I don't believe that police officer. I don't believe that police officer when he says that the victim said X. And then the jury has to decide, do we believe the police officer when he said that, or do we believe the victim? And based on what they see about the victim and their assessment of that victim at trial, they say, I find the victim credible, I don't find the police officer
Well, they
credible.
believe the officer, but they think there may be a mistaken translation.
Correct.
Well,
It's not about thinking one of them has perjured themselves.
no, but that, there was no issue raised at trial about whether there was a mistaken translation.
But
Is that-
I think the point about what you're hearing is you would have a stronger case, perhaps, if there was a videotape, for example, of his statement at the time, and it was inconsistent with what he said at trial, or if he acknowledged that he had said something different at trial.
Well,
But here it's filtered through the police officer's recollection.
Well, not just his recollection. As the prosecution has argued several times in this case,
His
he had
testimony-
contemporaneous notes
Okay.
of the conversation.
Understood, but it's filtered through the police officer's
It's still hearsay.
recitation of what happened at the time, not him directly.
Plus, Your Honor, if the prosecution wanted to dispute,
Yes,
he would
but
say-
also plus, there was a police officer who served as an interpreter. English was not the first language. This person got off of work in the early morning hours, fell asleep on his train, was disoriented. Isn't it for the jury to decide the circumstances under which the notes were taken as to whether their accuracy or whether they accept as true that which was given under oath at trial before them?
Your Honor, I think there are a number of points in what you said where the record doesn't support that. The record doesn't support that he was disoriented. The trial prosecutor argued that right after the crime, he was alert and awake, not confused.
He was awakened. At some point, he awakened.
Yes.
He fell asleep on a train. What I'm simply saying to you, these circumstances under which, it's up to the jury to consider, the circumstances under which the officer transcribed what was given, what he believes he received, and then later, under oath, a witness testifies. The other concern I have here is what happens when officers take down cursory notes? Is a witness, alleged victim of a crime, then bound by that statement when it wasn't even a complete and accurate recitation of the facts?
Not at all, Your Honor. The witness can offer an explanation. That's what happened in the Delamata case. The witness offered an explanation, said, the police officer's recollection of what I said
But
is
here,
wrong.
the witness doesn't say,
He doesn't say-
doesn't say there was a contradiction.
No, he
Doesn't say that was my statement.
Well, he was confronted with it as a contradiction, and he says, I don't remember.
So
No, he
let's-
doesn't
let's-
say I was
let's-
too tired, or I
Let's
was...
suppose that the Jackson rule applies just for the sake of argument. Why aren't the points that Judge Troutman referenced a reason for the jury to prefer one over the other?
Because the record doesn't support any of them, Your Honor, frankly. There's no evidence that he was upset
No,
or
no.
tired at the time. he gave-
Just the fact that this is actually taken down by a police officer who clearly didn't record the statement verbatim, wouldn't it be a sufficient basis for a jury to conclude, I have a basis to pick one over the other, because
Well-
one is what the witness has actually said, and the other is what somebody says the witness said.
Well, there's one point I think that's very critical to that, Your Honor, is that there's a very big difference between what the police officer says that Herrera said at the time of the crime and what Herrera testifies to at trial.
Well,
This is
of course, if it weren't contradictory on a material issue, we wouldn't have a Jackson issue at all.
not a
So-
difference in details. There's no way that he could have just misheard a word or two.
But that sounds like a jury argument. I'm asking you something a little different, I think, which is, why isn't the fact that this is the officer's recitation of what the officer heard a reason to prefer the in-court testimony?
Well, if that were the categorical rule, Your Honor, then perhaps, but Delamata, I think, it has language contrary to that. Plus, the court has always, whenever the issue has come up, I believe, proceeded on the basis that the sole witness rule does apply here. Another case is the Calabria case, where the court ultimately decides it's a minor discrepancy in identification. That's not sufficient for an irreconcilable inconsistency. But it says it treats it as if the sole witness rule would otherwise apply. In Delamata, if the sole witness rule didn't apply, the court was very sharply divided 4-3. The majority would have simply said,
No,
said
all of my questions start from the premise that the sole witness rule does apply, but there is a basis that the jury had to distinguish between the two, to pick one over the other.
no, the point of the sole witness rule, Your Honor, is that you don't send the case to the jury. If the sole witness rule applies, the case should not be submitted to the jury.
So let's suppose we have a domestic violence case, and there's an incident of domestic violence, and when the police show up, the woman says, he didn't hit me, nothing happened, nothing to see here, but then months later testifies at trial that there was an assault.
Then
Are you saying that,
she explains.
as a matter of law, that case can't go forward?
If she were to say, I have no recollection of what I told the police, but said something like, I can't possibly have told them that, or says, I told them that, but
What if they say, I don't remember saying that? What if you say, I don't remember saying that? Is that enough?
I don't think that's enough, because I think what a witness would say in the situation of that hypothetical is, I don't remember saying that, but that's not true. Here's my explanation.
Isn't that what they basically said in this case? I don't remember. You know, they say, did you say this? It's like, I don't remember saying that, and then they testify to what they say happened.
But they don't say something like I think someone would say in the situation, which is, I don't remember saying that, but I couldn't have said that because it simply is not what happened. It's not true.
Yeah, but he's under oath. He's under oath. He's saying, having taken that oath, this is my recollection of the events.
Yes.
You really need to say, well, I can't remember that, but if I said that, that would be incorrect. This is what occurred. Isn't that what he's saying by saying under
Then
oath?
the jury's left with no explanation. If were a videotape deposition introduced, it would
But
still
they're
come.
left with the explanation of, I don't remember saying that because I didn't say it. And then, as the chief judge was saying, it's up to the jury to whether to believe the officer or the witness.
Well, he didn't say, I don't remember saying it because I didn't say it. He just said, I don't remember whether or not.
Doesn't
I said-
remember that. That's true. But I think you're forgetting that indeed, it's not actually the officer who testifies who heard him say a blessed thing. It's someone else who heard, who the prosecutor is arguing, speaks English and Spanish, heard the gentleman, the victim, explain what happened, and then translate that into English for the officer who actually testifies.
Yes, Your Honor.
There
but-
are lots of incorrect interpretations and translations. So it would not be a shock that a jury might wonder whether or not they got it right at the site where,
There's nothing
crime
in this
occurred.
record that would suggest the jury even considered that. No one at trial said there was any problem with
So
translation.
would it be enough for you if the prosecutor in closing had said, I know there are these inconsistent statements from the police officer, but that was through a translation and it's recorded by the officer, not the actual person's statement, that's a basis for you to choose?
No, I don't think that would be sufficient because there are, in fact, cases directly on point about that where prosecutors argue to the jury that some discrepancy occurred because of a translation problem, but there was no evidence of translation problem.
Well,
It
does-
never came up during the evidence, and that's held to be reversible error.
does anyone, the prosecutor, the witness, does anyone actually need to say, you should think about it this way, this might explain this, as opposed to, here's the record and the jury can make appropriate, reasonable inferences?
It's not only a
on that
matter of
record.
thinking about it, it's a matter of that there's no evidence of any mistake.
But you
No-
agree no one has to point to it? That if the record had a
Oh, if-
way to make this determination, that the jury could do so? Do you agree with that?
But then something would have pointed
Is
to
that a
it.
yes or a no? I'm just
Yes,
wondering.
but the answer, the reason for that yes is because then something would have pointed to it.
So you're saying the jury could not just take into account all the circumstances? They're instructed, I think, something along the lines of they weigh the testimony in light of all the circumstances that they find exist. And you're saying unless somebody adverted their attention to whatever the problem might be, that they're prohibited from considering certain circumstances?
No, what I'm saying, though, is in the context of the sole witness rule, that's not the solution, because even in a case where
But the solution in the sole witness rule is a drastic remedy. It takes from the jury an issue, right? So in the original sole witness line of cases, you had a witness who got up on the stand and gave two diametrically opposed versions of what happened, conflicting. Later gets applied to an excited utterance versus a later statement in court. But what you're asking here is, as a matter of law, we remove a credibility issue from the jury based on a detective's statement about what this witness said before that the witness says, I don't remember making.
He says, I don't remember whether or not I made that, yes. Yeah, I think that has to follow, Your Honor, from the absence of any explanation. I mean, even in the situation where there's internally inconsistent trial testimony, the jury could say, well, it's a credibility issue. I believe what the inculpating testimony and not the
And
exculpating.
we've said in that very unique circumstance, the judge can take that issue from the jury, because here is a witness that the jurors heard right on the stand, under oath, give two conflicting versions of a story. And that's not what happened here.
But Delamata says that in the situation that happened here, the lead one rule applies.
Well, we can disagree on exactly what Delamata says, and I think there's room to disagree on exactly what Delamata says.
The dissenters in Delamata certainly relied on the lead one rule.
Right, but the majority says, with these principles in mind, we conclude that lead one rule does not direct the outcome of this case,
Oh.
which to me seems somewhat ambiguous, whether because of these other factors in the testimony, or whether because given what lead one is getting at, it just simply doesn't apply. But I think the way to read Delamata, to me, is it has to impeach the witness to such an extent that we remove the issue from the jury.
Well, yes, but, well, two things, Your Honor. First, if the rule didn't apply in Delamata, the majority could have simply said to the dissenters, this rule just doesn't apply here. They didn't say that. They went through a whole analysis, and they said, in the situation covered by lead one, we can reverse based on a conflict between pretrial and trial
Well,
statements.
certainly that's what happened in Fratello, but the pretrial statement came in for the truth.
Yes, I know, Your Honor, but I don't think anything in Fratello indicates that that fact played any part in
But
the
it
sole witness decision.
It does seem
Those-
the arc here is going from direct testimony in court to Fratello statement admitted for the truth to a collateral attack on credibility, which raises different issues in terms of the province of the jury.
Well, it's again, the issue here, as I think we've all been discussing, is credibility. And if a statement's admitted to impeach credibility, then why isn't it directly part of the problem here? The problem isn't something other than the credibility of the witness. That's
You're
what it's
then
for.
using the exception to drive a rule, to me, it seems. The sole witness is an exception to that exact decision being a jury issue. And now we're saying, well, since you have this sole issue rule, now we're going to walk it backwards to a collateral attack on credibility because it's a credibility issue. But the fact that we take that from the jury in a sole witness case is the very, very rare exception.
I agree, sole witness cases are rare. But the circumstances of this case are quite rare, too. In every other case I've seen where you have a conflict like this, the prosecution is always, witnesses have expressly testified to a reason why this occurred, either,
But see, you work from the presumption that there is a conflict. And that's the point that I was asking you about at the beginning. Who resolves whether or not there actually was a prior inconsistent statement? There's obviously a statement. I don't think that's debatable. Question is whether or not it's inconsistent with the trial testimony.
well, I think.
Is that for the jury to decide, or is that to take it away from the jury?
I think there's two issues at play here. One is the impeachment
Yes.
question, which I think
Yes.
is separate from what you're asking about,
Yes.
Your Honor. And the other is, how do you decide that question? I would say that in the circumstance where the prosecution does not ask any witness about the conflict, does not have any witness say, here's why those statements were given. Doesn't ask any witness to explain that or dispute it. Just ignores it altogether and never even mentions it in summation to the jury, which is what happened here. There's absolutely no explanation in this record. That situation where the
I'm not sure it's easy for me to distinguish between a witness who gets up and says, I never said that, and one who says, I just don't remember.
Well, if he says, I don't remember, then
Because
he...
both of those allow a jury to decide whether or not there really is a conflict.
I think if he says, I don't remember, then there is a conflict, Your Honor. He's not offered any dispute that it occurred, and the prosecution has put on another witness who says this is what occurred. There's 2 other police officers in this interview. Neither of them dispute what occurred. There's no evidence of any translation mistake. Again, I would also point back to the magnitude of the difference here. Herrera's testimony trial is, I woke up, a man was standing by me holding a box cutter, demanding my property, and I handed my wallet to him. What the police officer, Burnett, testifies to that Herrera said right after the crime was, I woke up on the subway, a man had my wallet, dropped it, and ran away. I don't think a magnitude of that kind of difference can be explained by a translation mistake, and especially when there's no indication.
I've read a lot of them that are even more inaccurate than that, FYI.
I don't see how any Spanish-speaking police officer, bilingual officer as we had here, could have interpreted, I saw a man standing there who dropped my wallet and ran, and make it into, or rather the reverse, who could have heard the witness say, I saw a man standing by me with a box cutter who demanded my property, and I gave him my wallet, could turn that into a statement. No mention of a box cutter, no mention of a demand, no mention of handing over his wallet.
It's a very good closing argument to the jury.
But then there's again, it would mean that there's a categorical rule that if it's a pretrial statement and a trial testimony, as long as the witness doesn't say, I did say that, if all the witness says is, I don't remember whether or not I said that, and so there's no dispute, and the prosecution has put on witnesses to testify or do testify that he did say that, and no question is raised about it at trial, did he say that or not, other than the witness saying, I don't remember it. And you have the arresting police officer whose job it is to do this, who has notes on this, and you don't call the other 2 police officers, and you don't make any argument to the jury. In those circumstances, I think you don't have a genuine issue of fact, let's put it that way, about whether he made the statement or not. If this were a summary judgment motion in a civil context, and the police officer came in and said, this is what he told me, and the witness who supposedly told that said simply, I don't remember if I told him that, would there be a genuine issue of fact in a civil context about whether that statement was made? I don't think so.
Thank you, counsel.
Good afternoon, Your Honors. Jordan Cerruti for Respondent, the people. Please the court. Defendant's claim is not preserved that complainant Mr. Herrera's testimony was credible as a matter of law because of this alleged prior statement. In the motion for a trial order of dismissal, counsel never argued that the trial testimony was incredible as a matter of law, never compared the trial testimony, never mentioned the trial testimony, never compared the statement to the trial testimony, simply adopted the statement as that's what happened. This did not fairly alert the court to the claim. In any event, there was objective rational bases for the jury to credit Mr. Herrera's trial testimony over Officer Burnett's testimony of this alleged prior statement. The jacket itself, the jury could see.
Do you think Mr. Herrera made an inconsistent statement?
Do I think? Well, I mean, that was for the jury to determine. I think they have there's a basis in the record for the jury to determine this statement was not made as Officer Burnett remembered it. The circumstances that Mr. Herrera communicated with Officer Burnett through this unofficial interpreter, This was late at night after
When you
Mr.
say unofficial, that suggests to me that you think there's something, maybe second-rate about it. But I thought that was an approach that was pretty widely used.
I think it is presumably an approach that's pretty widely used for the purpose of getting an initial cursory statement
It's an
from,
investigatory tool.
an investigatory,
Should
initial
we look
statement.
askance at it as a general matter?
Well, I mean, I think the question here is, did the jury have a basis to credit the trial testimony over Officer Burnett's recollection? And they do. I mean, in comparison, Mr. Herrera gives testimony under oath. This was for the truth of the matter. This was the product of questioning and cross-examination. It was
Right, I'm just focusing specifically on the translation point. I would guess, although you'll tell me, that there are a lot of cases in which there is a translation. I'll give it a second. A translation that's obtained under similar circumstances, and the people would rely on it and treat it as a good translation. That's a different point than whether the jury could have concluded otherwise.
That's right, Your Honor. And the issue here is, could the jury have treated that as a basis for finding that this statement did not happen as Officer Burnett remembered? And they could have. Something was lost in translation, either Herrera telling it to the other officer, whomever that was who translated, who's an interpreter. We don't know how good their Spanish was. We don't know if they've ever done live translation before. We don't know if they spoke the same dialect as Spanish. We don't know if they were a native speaker. And then they then communicate to Officer Burnett. Does Officer Burnett remember it correctly a year and a half later? Did he take precise notes? Was Herrera the most articulate after he'd been up all night and been robbed and just wanted to go home? All of that gave the jury bases to credit.
I thought the prosecution argued at trial that he was alert and awake. Is that not right?
The prosecutor did argue that. I mean, their summation isn't evidence.
Yes.
And the jury had a basis in the record. Herrera fell asleep on the train because he was so tired, and then was woken up by defendant cutting his jacket. So he had been up all night except for this nap on the train. He testified that he was so scared that he couldn't even get off the train at first. Officer Burnett testified that he appeared upset. All of this was in the record for the jury.
Is it fair to say, though, that the prosecutor never never told the jury, here's a reason you could prefer the trial testimony over the statement recorded by the officer?
No, Your Honor. In summation, the prosecutor offered the jacket itself as independent physical evidence that could be a basis for the jury to credit Herrera's trial testimony. The jury could see the jacket itself. I mean, the jacket was put into evidence while Mr. Herrera testified, and he indicated the cut. And then the trial prosecutor handled it 2 times for the jury during summation, and specifically argued.
Why would the cut distinguish between truth and falsity of the 2 statements?
So the jury could see the cut that defendant made to the jacket only went through the lining of the jacket and didn't actually go all the way through to the pocket itself.
Did the prosecutor try to connect that point up to explaining the discrepancy in the statements specifically?
Yes.
Okay, maybe you could point us to where in the record that is.
On pages A569 and A583 to 84, the prosecutor argued that this cut in the jacket, quote, speaks volumes because the cut did not successfully go through the pocket and actually would not release the property inside, and therefore, Mr. Herrera had to be awake for this robbery and had to be awake when the person was taking his stuff because defendant was unsuccessful in getting his wallet by cutting the pocket. So the prosecutor is presenting Mr.
The alternative view, right? But is the prosecutor anywhere explicitly connecting that to the different statement from the police officer via translation?
I mean, I think that's implied. I think the jury.
But not explicitly.
Not explicitly. But the prosecutor is saying that this is the version of events that you should credit. It's Herrera's testimony, and the prosecutor specifically says, he had to be awake for the robbery. Well, the only version of the events that he wasn't awake for the taking of the wallet is this alleged prior statement. So the cut to the jacket was, independent physical evidence that gave the jury a basis to find that Herrera's testimony that he was woken up by interrupted defendant in the middle of cutting the jacket so that defendant couldn't get the wallet, and then defendant moved on to a second strategy, changed tactics, and instead repeatedly demanded the wallet, demanded all of Mr. Herrera's property while displaying a box cutter. The jury could rationally find that Mr. Herrera's testimony was accurate and truthful because defendant couldn't have gotten the wallet out of the jacket because the cut did not go through to the pocket. Mr. Herrera's testimony was, for its truth, not as opposed to the prior statement, which was merely to impeach. So the jury had before it the choice between consistent, unwavering, detailed testimony and did Mr. Herrera misremember all of these details? He has no motive to lie. Did he misremember all of these consistent details versus, or did Officer Burnett or the translating officer simply make some mistake somewhere along the line in exactly what Mr. Herrera said? If there are no other questions, the people ask that you affirm the judgment. Thank you.
Thank you.
Just a few points in response here. The claim was clearly preserved. The defense attorney argued that notwithstanding all the evidence in the case, because the witness told the police right after the crime that that conduct occurred that only amounted to larceny, that was the reason for dismissal. But as long as we're talking about preservation, I would note that none of the arguments the people have made here about what explanations the jury might have come up with were made at trial. For example, the translation argument, it wasn't raised at trial. If it had been raised, the officer could have been, the bilingual officer translator, could have been called in, could have been asked about his qualifications. The police department has a program to certify bilingual officers as experts in translation, and they had it at the time of this crime. So, but the defense had no opportunity to explore any of that because the prosecution never raised the issue at trial. They never raised the issue at trial about whether Herrera gave an incorrect statement because he was too tired or upset.
Well, what about the pocket? What about this other evidence?
The pocket,
The cut in the pocket.
yes, there's at least three things wrong with that argument. First is Herrera didn't say anything in his statement to the police right after the crime about how the wallet was removed from him. There's absolutely no evidence to indicate that the defendant could not have just, when he had trouble cutting, stopped cutting, reached into his pocket and taken out his wallet. There's just, so there's nothing to support the inference that the defendant could not have removed the wallet.
Isn't that the evidence that your adversary just adverted to, that he could not have completed it that way because he never got through the pocket?
No, I'm saying he could have completed it a different way. He could have completed it just by reaching into the pocket and taking the wallet out.
Oh, without using a knife, just putting your hand in the pocket?
Well, once he found it hard to cut, he could have reached in the pocket and taken the
Well,
wallet out.
that's one particular inference. Why isn't the inference that he suggested enough for
No,
purposes of
the inference
avoiding the
inference he's
single
suggesting is
witness?
that it was impossible to remove the wallet in any way other than by cutting through, or him being awake. And if that's the inference to be drawn that it was impossible, it's clearly wrong. Unsupported. Second, the prosecution did not relate the jacket point in any way to the prior statement. What the prosecutor was doing was saying, how do we know that this man, the defendant who's been identified here, was the person who actually committed the crime? Well, we know it because, or we will know it if the witness got a good look at him on the train. She was talking solely in the context of identification. She never mentioned the prior statement. And what she was effectively saying was, well, looking at his trial testimony, the cut didn't go through, so he was awake as a result, and so he got a good look at him, and therefore you should trust his identification. In no way was that related to the prior statement, which again doesn't exclude the possibility of the prior statement that he just reached into the pocket and removed the wallet. And third, in the sole witness,
Without waking him,
excuse me?
without
Right.
waking him, ruffling, going in that pocket without waking him.
Well, he did wake up shortly thereafter. He saw the man standing there, he said, holding his wallet, and who dropped it. I mean, the reason, as I understand it,
Yes,
why-
no, but as I understand what you're suggesting is that they cut enough to be able to reach in and step back, but that wouldn't have woken up, right? If
No,
I'm
he-
understanding you?
Yeah, the way this jacket is a little complicated. The outside layer of the jacket doesn't form part of the pocket. The pocket hangs inside the jacket. So the cut went through the outside layer but didn't go into the pocket. But what I'm saying is, when he was cutting, there's absolutely nothing to exclude the possibility that when he was cutting and realized he wasn't getting through quickly enough, he just took his hand, reached in the pocket, and removed the wallet. What the prosecution is saying now is that was impossible. The only way it could have been removed was if he was awake, and that's
I'm sorry,
inference.
are we talking about a jury argument or argument made to the court on the motion for a dismissal? These allegations that you're referring to? Because one to me sounds like a credibility argument, and another one sounds more like a legal argument.
No, the argument about whether it was impossible to remove the wallet from the pocket
Right.
never came up during the course of the evidence. No witness was questioned about that. Came up for the first time in the prosecutor's summation after the defense had already summed up. The argument was solely about identification, that he had to be woken up in order to get the wallet, and that meant he could give identification. But the prosecution now, for the first time in this court, is trying to draw a different inference from that. It's trying to say, well, the prosecutor's argument about a trial about how he had to be awake means that it was impossible for him to have removed the wallet while Herrera was sleeping, and therefore Herrera's trial testimony must be correct. But there's absolutely nothing about that that establishes that it was impossible for him to remove the wallet while Herrera was sleeping. When under Herrera's own testimony, when he's asked for his wallet, he reaches in, hands it out. Herrera says, I gave it to him immediately. There's nothing to say that the defendant couldn't have reached into his pocket and removed it. Nothing
you,
in
counsel.
Herrera's statement.
Thank you.